just a few slides ago. So without any further ado, I am excited and delighted to introduce Bill Current, today's keynote speaker. Bill is a consultant in the drug testing industry, building business policy for corporations in this regard. I sent Bill an article this morning. I saw it last night. I know he's going to cover it in his slide deck. This is a very fluid, a very active part of our country, its culture. It's a very active part of your days as employers. And we couldn't be more delighted to have an expert such as Bill join us today to give us an update on where we are today. So Bill, without any further ado, I'll turn it over to you.
Thank you very much, Jeff, and welcome everyone. If you've been on an Orange Tree webinar in the past, you know we do an excellent job. And it's always just a pleasure to participate in an Orange Tree webinar. So glad to be here today, glad you're with us. I invite you to submit your questions, use the chat function. I think it should be somewhere on the bottom of your screen. You should see this chat function. And if you'd like to submit a question on any topic related to drug testing, I will be happy to address it. I know we've got one question already. Let me just advance past a few of these things. I will say that actually my first book that I actually had published was called A Guide to State Drug Testing Laws and Legislation. I co-wrote it with two other people back in like 1990. And at that time, there were just a handful of drug testing laws, state drug testing laws. And so it was kind of an easy book to write, and it was easy to memorize all of those laws. Today, 30 years later, thereabouts, there are hundreds of drug testing laws, state laws that touch on drug testing, state laws that are dedicated to drug testing, workers' comp laws, unemployment comp laws, legal marijuana laws that touch on drug testing. So today it's impossible to have it all memorized and answer questions off the top of my head on particular issues. But if you have a question and I don't have an answer for you today, I'll get the answer for you and we'll get it out to you through Orange Tree. So we're going to talk a little bit about types of drug testing laws and how they affect workplace programs. We'll compare that to federal laws. We'll look at some case law examples because some states don't have drug testing laws. We'll also compare DOT drug testing requirements with non-DOT requirements, and we picked a few states to give an example of that. And then we'll talk about the value of drug testing and how to measure your return on investment. So as we sort of set the table, let's just look at a couple of slides that talk about the level or the magnitude of the drug problem today. Every year, the federal government puts out a report on substance abuse in the drug testing in the United States, on substance abuse in the United States. Let me go back to that previous slide here. I think I advanced too quick. Jeff, I'm not able to go back. Can you take us back to the previous one? There you go. Thank you. So this is past month substance abuse. And substance abuse in this survey includes everything from alcohol and tobacco to heroin and inhalants. And you can see on the pie chart to the left that 60% of the population admits to using anything from alcohol, tobacco, marijuana, cocaine, etc. In the past year, or excuse me, in the past month. So it's 60% in the past month. Now on the next slide, well, actually, this is the next slide. If we go to the previous one to this one, let's go back one more slide. Okay. I apologize. I must have taken that slide. Oh, here it is. Okay. So I was just going out of order. If we look at past year drug abuse and just look at illicit drug use, we take out alcohol and tobacco, then marijuana becomes the #1 substance of abuse. And about 20% of the population 12 and older admit to having used one of these drugs that you see on the right in the past year. That's a significant percentage of the US population, 12 and older, admitting that they're using illicit drugs. And when it says in the past year, it doesn't mean just once in the last year. It just means that they're only willing to admit that they've used drugs at least once in the last year. Many people have a bigger problem than that. And part of the reason why marijuana is going up is the legalization, of course, but the message that comes with legalization, which is that there's no harm in using marijuana on a regular basis, on a weekly basis. So in the middle, you see cocaine, you see heroin, and the perceived risk of using these drugs on a weekly basis. But on the left, the bar drops dramatically when we ask people the perceived risk of using marijuana on a regular basis. And that's leading to a lot more people using marijuana. The availability through legalization and the messaging that comes with legalization that there's no harm in using marijuana, which is not true, is leading to a lot more people using marijuana. So it requires employers to take a comprehensive approach to protecting the safety and the health of your workplace and your workers. And so you've got to have a policy, you do training with employers and supervisors, and you do drug and alcohol testing. And you review this program at least on an annual basis to make sure that, one, it's working, that it's meeting your needs, and two, that it's in compliance with the laws that apply to it. The policy itself contains a lot of different aspects, but if it's not written to take into account the laws that apply to your company in the states where you do business, then your policy is no good. It's not protecting you because you haven't written it to comply with the applicable laws. And so let's talk about that for a minute. Okay, let's look at state, federal, and federal laws, and then case law as well, and how it impacts what you can do in your workplace as far as a drug testing program goes. So we know that during the pandemic, substance abuse has been up dramatically. Most experts believe that the percentages I just showed you are probably going to increase by about 30% when the new government study comes out reflecting 2020 drug use trends. That will be the largest, most significant increase in 1 year in the history of the survey, which dates back to the 1970s. The federal government continues to require employers to do drug testing in certain industries like the transportation industry, and state drug testing laws are still there. They haven't gone away, they haven't been suspended, they've not been eliminated, they still apply. And so it's important that we keep track of these things as well as legislative developments that are occurring all year long and from year to year to year. And I'm going to show you some good examples of that. So when you talk about state laws, there are different types of laws that we need to concern ourselves with for workplace drug testing purposes. At the state level, there are what we call mandatory drug testing laws and voluntary drug testing laws. And you see the numbers off to the right. Some states don't have either a mandatory or a voluntary drug testing law, but 17 states have mandatory laws, meaning that every employer who wants to do drug testing must comply with that law. And 16 states have what we call voluntary laws, like here in Florida, where I live, where the state offers a workers' comp premium discount for companies that join that program and drug test according to guidelines from the state. And there are 16 states that have those, either a workers' comp discount law or some type of legal protection from liability if you comply with the voluntary law. Every state has case law where courts have made decisions or ruled on particular conflicts that now govern or sort of explain different things within a state law. Many states have workers and unemployment compensation laws with drug testing regulations in those laws. Every state has a workers and an unemployment compensation law, but there are states that have specific guidelines for drug testing, meaning that if you want to move to deny workers' comp benefits, for example, for somebody who was injured on the job, then you have to be able, and related to a drug testing result, you have to be able to show that you drug tested in a way consistent with the workers' comp law in that state. And not every state has that type of law, but all states have workers' comp and unemployment comp laws. Then there are some states with industry-specific laws. In Illinois, for example, excuse me, it mandates drug testing of public works contractors. In Kentucky and West Virginia, it's for the mining industry. And so you need to be aware of those if you're in those industries. And then, of course, I've got a bunch of slides coming up on marijuana, but medical and recreational marijuana laws often nowadays have workplace-specific language in them that can affect a drug testing program. So back in November, we saw several states vote to legalize recreational marijuana. Arizona, Montana, New Jersey, and South Dakota, and Mississippi and South Dakota again also voted to legalize medical marijuana. So the number of states that now have medical marijuana laws has increased dramatically, and those have to be taken into consideration when you look at the laws in a particular state. Here's West Virginia as an example. There's a little, now this is from our website, the current compliance website, which you can find more information about this through Orange Tree, but it gives you a little heads up on the law, but then it shows you all the different laws in that particular state that can affect workplace drug testing programs. The purpose in showing you this slide is not to brag that I've got all this information, but to show that in a state like West Virginia, which is not a state that has a lot of different laws, you see what appears to be a lot of different laws. It's not California where you would see a whole plethora of case law decisions that affect drug testing, or Iowa, which has a very specific drug testing law that applies to all employers in that state. But even in West Virginia, we find that there's marijuana laws, there's workers' comp and unemployment comp laws that affect drug testing in the workplace. If we go back to this whole concept of keeping track of legislation, I mentioned earlier that New Jersey voters voted to legalize recreational marijuana, but there was nothing in the ballot, public question number 1, it was called, on the workplace. And so since that time, the New Jersey legislature has passed a series of bills, which the governor has now signed, that add detail to the recreational marijuana law that was passed by voters back in November. And so there's one of those bills, AB 21, has some very specific language that employers need to be aware of. And those things need to be reflected in your policy. That's just happened since the first of the year. Idaho passed a law exempting from the definition of marijuana certain FDA-approved medications, and Iowa passed a law that makes it a criminal offense to cheat on a drug or alcohol test. Those are things that should be reflected in a comprehensive program and in a comprehensive written drug testing policy so that you as the employer are protected in situations involving, in this case in Iowa, somebody trying to cheat on a drug test. Those things should be reflected in your program. Now, since November, this is what the marijuana State of the Union looks like in terms of legalization. The orange states are the recreational marijuana laws, the blue states are the medical marijuana laws, the white states are the no legal marijuana laws. But all of the blue states, all of the medical marijuana laws, all of the orange states, all of the recreational marijuana laws states already have medical marijuana laws in place. So really, in effect, the orange states should be some combination of blue and orange because they have both medical marijuana and recreational marijuana. And you can see that the map is really becoming quite colorful because a lot of states, about 35 states now, have made marijuana legal or they've decriminalized it in one way or another. And it's led to an increase in marijuana use, which is directly impacting the workplace. So you can see between 2018 and 2019 that marijuana use increased significantly from, as you look at the percentages there. And it's kind of hard to see inside the bar, but you're looking at an increase from 15.9% in 2018 to 17.5% in 2019. And 2019 is the year that the 2020 survey reflects. So it's the latest information from the federal government. Other drugs may be going down in their usage, like psychotherapeutic drugs you see just below marijuana, but marijuana is going up significantly. To go up 1% in a single year is a dramatic increase when it comes to drug abuse. And you can see that in the case of marijuana, it went up even more than that. These marijuana laws often have language in them more today than 5 years ago. They have language in them that touches on the workplace. So you'll find employee protection language in these laws that basically says an employer cannot discriminate against a registered medical marijuana user. And furthermore, if an employer wants to use a positive drug test for marijuana to take some type of adverse employment action, he or she must be able to prove a corresponding impairment of the individual to go along with that positive drug test result. Well, a drug test result doesn't prove impairment. So you've got to have other proof to go along with the drug test result. Many of these laws, not all of them, but some of them have employer protections written into them that say that the employer does not have to permit marijuana use in the workplace. and does not have to tolerate workers being under the influence of marijuana while on the job. Again, the drug test itself from a scientific and legal standpoint does not prove impairment, no matter what the drug testing method is. There's some good drug testing methods out there, but from a legal and a scientific standpoint, they don't prove impairment. There's no such thing as a sort of a window of impairment, and this result from this method or this result from that method is going to capture that window. Impairment is caused by many different things, but when it comes to drugs, you've got to take into account the drug that was used, how much of the drug that was used, when the drug was last used, the tendency of the individual to be affected by drugs, et cetera. And so a lot of issues have to come into effect. That's why it's important to have other impairment identification tools in use. You don't have to take the adverse employment action based solely on the drug test result, but the drug test result can be used as part of an overall story or telling of the history of that individual to justify whatever adverse employment action you want to take. But in doing so, you need to know what these legal marijuana laws say if you're in a state that has such a law. Nevada, for example, does not allow employers to refuse to hire a job applicant because they tested positive for marijuana. There are some limited protections for safety-sensitive industries, some exceptions. But generally speaking, you can't fail to hire someone simply because they tested positive for marijuana. It's almost as if the individual has a free pass to come to the job interview high on marijuana because you can't use just the marijuana positive drug test result to refuse employment. In New York City, there's a prohibition on testing for THC altogether in pre-employment testing. There is, however, a lengthy list of safety-sensitive occupations that are exempted from that prohibition, which you see this in a lot of states, like Nevada, like New York City. And when I say New York City, I mean New York City. I'm not talking about the state. This is a city ordinance. But you do find a lot of these states with very restrictive language when it comes to pre-employment testing for marijuana, including a lengthy list of exemptions from the law for safety-sensitive positions. It tells you that the lawmakers know that marijuana can adversely affect somebody's ability to do their job. And if that job involves safety-sensitive functions, they don't really want people high on marijuana doing those types of jobs. So it's a little bit of a hypocrisy in a way if you look at it from the perspective of, either we allow people to use marijuana or we don't. In this case, they're trying to have, sort of their proverbial cake and eat it too. Now, something that Jeff brought to my attention just this morning was a Supreme Court ruling in the state of Washington. So the Washington State Supreme Court. And this is from an article in the Federalist that just came out. But basically the court ruled, and there's a little bit of political posturing here in this paragraph, so ignore that. The basic premise of this ruling, though, is that whether it's heroin, crack, opioids, synthetic opioids, etc., they're no longer criminalized to possess and to use those drugs in the state of Washington. Now look up at the top of my screen, you'll see that Oregon voters passed an initiative back in November limiting essentially decriminalizing possession and use of magic mushrooms, as we would call them, and decriminalizing possession of all Schedule 1 through 4 illicit drugs. Well, Schedule 1 is heroin, cocaine, marijuana, and Schedule 2 and 3 often contain various medications. Now it's no longer illegal to possess those drugs if you're possessing a personal use quantity. The District of Columbia voted to decriminalize magic mushrooms as well. But now we have this Supreme Court ruling in Washington. This is significant. It's starting to actually go beyond the legalization of marijuana to the legalization of other drugs. We know that since the legalization of marijuana really took hold, the use of marijuana has increased dramatically. And there are statistics from laboratories that show that the rate of positive drug test results for marijuana has increased along with that usage rate. So if we're starting to make it less of a problem legally to use heroin and cocaine and synthetic opioids, et cetera, we can probably expect to see an increase in those drugs as well, an increase in the use of those drugs. And I say that within the context of this presentation, because as an employer, you've got to test for the drugs that people are using. Marijuana may be at top of mind because it's so prevalent, but if you just test for marijuana, or you just test for marijuana and alcohol, for example, because they're number 1 and 2, then you're really shooting yourself in the foot because people are using these other drugs. And during the pandemic, we've seen a dramatic increase in the use of opioids and amphetamines. One drug testing company reported that back in June, that the percentage of positive results for opioids from random tests had increased over 600% since the start of 2020. So in a 6-month period of time, they saw a 600% increase in positive drug test results from random tests for opioids and about a 400% increase for amphetamines. So we've got to test for the drugs people are using, or else we're actually allowing people to be at work under the influence of these drugs. I won't pause here for very long, except to say that there are a lot of case laws. Every state has them. The states like California, which tend to be a little bit more liberal and don't have state drug testing statutes, rely heavily on case law developments to sort of govern how drug testing in the workplace occurs in those states. So as you're putting a program together, it's not enough to simply look at the drug test laws, but you have to look at the case law developments as well. Let's shift gears for just a minute. Let's talk about DOT drug testing. DOT drug testing accounts for over 6 million drug tests a year. These are various agencies within the Department of Transportation that require, that mandate drug testing of certain safety sensitive occupations within those industries. For example, at the very top, you have the Federal Motor Carrier Safety Administration, truckers, truck drivers, et cetera. They have their own separate drug testing requirements, their own separate regulations, and they account for the majority, the vast majority of the 6 million plus drug tests that are conducted every year as a result of these DOT mandates. And if you fall under any of these, Federal Motor Carrier, Federal Railroad, Federal Transit, the FAA, the Pipeline and Hazardous Materials Safety Administration, as you see there, and then the Coast Guard at the very bottom, which is not actually part of DOT, it's part of Homeland Security, but it has mandated drug testing regulations and was anciently part of DOT. If you fall under any of these federal agencies and you employ people who perform designated safety sensitive jobs, then you have to drug test according to those regulations. And your policy can't be the same as your non-DOT policy. You have to have a separate policy for those DOT programs. You can't collect a urine sample, for example, to do a Federal Motor Carrier Safety Administration required random drug test and use that same sample for your non-DOT. You have to collect a completely different sample, et cetera, et cetera. That's how specific and particular the DOT regulations can be. So this is not a presentation on the DOT regulations. That would require its own 3-part series. But if you fall under any of these federal agencies, you must comply with their regulations, or there are penalties involved. And all of the regulations are different. And here's just one example. These are the random drug testing rates for 2021 from each of the different modes. I don't show Coast Guard on here, but you can see that Federal Motor Carrier Safety Administration is 50% random testing for drugs, 10% for alcohol. But if you go down to the bottom, the Pipeline and Hazardous Materials Safety Administration, PHMSA, also requires 50% for random drug testing, but doesn't require random alcohol testing. Again, one size does not fit all. And this is just one example of how those regulations differ from agency to agency. So let's compare the DOT regulations with non-DOT drug testing, just to give you an example. Now, and I'm going to show this slide again that was at the very top of my presentation, because it's important that you understand that it's not just drug testing. It's a lot of different things that working together makes for a comprehensive approach that's going to have a better chance of helping you achieve your drug testing objectives, the things you hope to get out of drug testing, will be achieved if you have supervisor training, if you have a comprehensive policy that reflects state laws, et cetera, et cetera. So it's a comprehensive approach that you're looking for. So let me give you just a few examples. So there's some program components listed on the left, and then there's the DOT, and I use Federal Motor Carrier as my example, okay, as opposed to transit or railroad or aviation. And then I chose Minnesota right there in the middle as an example of a state with a mandatory drug testing law. And then I chose Florida as an example of a state with a voluntary drug testing law. And then California is the ideal state for an example of a state without a drug testing law, but with tons and tons of case law. So let's just look at the first point, a written policy. Under the DOT regulations, under Federal Motor Carrier, it's required. Under the Minnesota mandatory law, it's required. In Florida, if you participate in the voluntary workers' comp premium discount program, a policy is required. In California, with all the case law that they have, there is no case ruling that says an employer has to have a written policy. Should you have a written policy in California? 100%, absolutely, no doubt about it. But you're not going to find a case law that necessarily directs an employer with the content of that policy like you will with DOT or in the case of Minnesota or Florida. An employee assistance program under the DOT, it's optional. It's not mentioned in the mandatory law in Minnesota nor in the voluntary law in Florida, and there is no case law in California. But supervisor training and specific types of training for specific periods of time is required under the DOT regulations. It's mentioned and permitted in the Minnesota law. It's actually not mentioned, it's not mentioned in the Minnesota law. It's not mentioned in Florida, and it's not applicable in California. Drug testing, generally speaking, is required under the DOT law. It's permitted in Minnesota, but not required unless we were talking about a specific industry. In Florida, under the voluntary law, if you're in that program, you must do drug testing. In California, case law permits drug testing, but restricts different types of testing. Like the next line down, random testing, you'll see under California, it's restricted by case law. It's required under the DOT regs. It's permitted in the Minnesota law. It's permitted in the Florida voluntary law, but it's restricted by case law in California. And if you go down the list, you can see others like lab testing requirements, the use of instant result devices, whether you can test with urine or oral fluid, which are the two most popular drug testing methods, and whether or not they're required or permitted, or in the case of oral fluid testing under DOT regulations, not allowed right now. Only urine testing is allowed right now. That's going to change, I think, later this year, but it's not allowed traditionally under the DOT regulations. Okay, so you get the picture, right? The DOT regulations are very specific, and state drug testing laws can be very specific also, but they're two different categories that you have to be aware of if they apply to you. So for example, we had a client come to us recently. We write drug testing policies. We had a client come to us recently. This was a good sized company. I won't mention their name because I'm sure you've heard of them, but they were in more than 30 states, let's say. A big company, presence in a lot of parts of the United States. They had a 2-page policy, a 2-page drug testing policy to cover their program in more than 30 different states. Well, what's the problem with that? Well, all of those states have either a different mandatory law, a different voluntary law, a different workers' comp law that relates to drug testing, a different unemployment comp law that relates to drug testing, and some of them had marijuana laws that affect drug testing. So this is an example of a company that would have needed a comprehensive policy with addendums for the various states that apply to that. And so you don't want to approach drug testing, and here are all the different ways that drug abuse costs employers. You don't want to add one more cost to the list of ways in which drug testing is hurting your business by not having a comprehensive policy in place that is customized to meet the needs to meet the requirements of all the various states that you're in. Now you're thinking perhaps, wow, I'm in 30 plus states. My policy is going to be 300 pages long. No, it's not. The majority of issues can be covered in a base policy, but there are going to be some differences that apply. For example, if you're in California and there's restrictions on random testing, you may not want to have such a restricted random testing in other parts of the country where you also have business operations. So there'll be an addendum for your program in California to help you comply with the California case law. Whereas for your operations in Texas and Florida, for example, you won't be encumbered by those same restrictions. That's why you want an addendum for in your policy to cover California. If you don't do that, then we can add another bullet to this page for the different ways in which drug abuse is costing your company. And that's through lawsuits that you're probably guaranteed to lose because your policy doesn't comply with the applicable state law or case law, and you're going about doing things that somebody could possibly legally challenge and then cost you additional funds, maybe even cost you your entire business. We've seen examples of that. So let's look at this. Let's see if I can, here we go. Let's look at the best practices for the policy itself, okay? And I'm gonna get into some details on each of these in a second, or a few of these in a second. The two most important are why do you drug test and who will be covered by the policy. Now, shouldn't drug testing and how you do drug testing be the two most important things? Well, yes, except for you don't know how you're going to drug test until you know why you're drug testing, and you're not going to know who you're drug testing until you've been very clear about what your drug testing objectives are. So the methodology and the process of drug testing may change, may vary depending on why you're doing drug testing. Let me give you an example here. Let's see, I think I want to go to the next one. Okay, so let's look at different drug testing objectives. These are the most common ones. And number one at the top of the list is safety. Most companies drug test to ensure the safety of their workplace, to reduce accidents, to reduce the number of workers' comp claims that are being filed, to comply with OSHA regulations, to reduce or at least control insurance costs, et cetera. That's usually number one. And that will have an impact on how you drug test and who you drug test. There are other reasons: productivity, controlling costs, protecting the health and the well-being of your workers and your clients and customers, having an effect on employee theft or workplace violence, as you go down the list there. And then, of course, complying with state and federal drug testing requirements. As I said, some states have actual drug testing requirements, not just laws that mandate how you test if you test, but that actually require you to test in certain situations, like in Illinois with its public works contractor law. Okay, but let's look at this for a moment. Okay, so why you drug test determines when you're going to test, right? And this also touches a little bit on who gets tested. So pre-employment testing, for example, is testing job applicants before they get hired. You're not going to make a decision about hiring somebody until you've included in that screening process the drug test. Pre-employment drug testing is legal in all 50 states. There may be some restrictions in states like Nevada, and it's a small list that place restrictions on what you can do with a positive test for marijuana when doing pre-employment testing, but pre-employment testing is legal in every state. Let me just put in a plug for pre-employment testing. During the pandemic, we saw unemployment rates skyrocket. And at the same time that a lot of people weren't working, we also saw a dramatic increase in drug abuse. A lot of people were trying to self-medicate their way through the pandemic, through the stresses and the strains and the anxiety of the pandemic. And so as the unemployment rate has started to come down dramatically, and it's below 7% now again, a lot of these people are coming back to the workplace, having spent the last 6 to 12 months using drugs at a much more increased rate. In fact, there's a study that shows that about 30% of people using drugs never used drugs before, but they started using drugs during the pandemic. So pre-employment testing is one of your best defenses against hiring people that maybe down the road are going to cause an accident or a workers' comp claim, or maybe be less productive because they're bringing that drug use habit from their pandemic days into your workplace as one of your employees. Reasonable suspicion, post-accident, and random are the other three most common drug testing methods. Pre-employment testing is by far the number one testing circumstance, but reasonable suspicion, post-accident, and random are next in line. And you would conduct those depending on the circumstances, right? So let's look at, oh, let me go back this slide here. You take me back one there, Jeff? There we go. Okay. So let's say, for example, your objective is to reduce work accidents in the workplace, to increase safety. And so it might seem logical at first that you're going to do post-accident testing to help with that. That may have some effect on accidents in the workplace, but a post-accident by its very nature, in the very name of the method, takes place after the accident has taken place. So probably the drug testing circumstance or method that's going to have the greatest effect on reducing accidents is random testing, because the employee never knows when the test is going to occur. It's random, and it deters drug use. In fact, I think I've got a slide coming up here that shows that about 30% of workers, or I say job applicants, say that they won't work for a company that does random drug testing. They won't apply for a job with a company that does random testing. So why you test determines when you test and who you test, but it also determines how you test. So you see urine testing and through a laboratory on the left, point of collection or instant result testing with urine in next to that, hair testing right in the middle, which is always lab, of course, lab-based oral fluid testing, and then point of collection oral fluid testing. So why you're testing will have a direct impact on how you test. Let me give you an example. So there are only 3 drug testing methods that have been endorsed by the federal government: lab-based urine, lab-based hair, lab-based oral fluid testing. Lab-based oral fluid testing regulations came out on October 25th, 2019, just before the pandemic, more or less. And those regulations are still in implementation mode. Hair testing guidelines were proposed in 2020. So a notice of proposed rulemaking came out from SAMHSA, the Substance Abuse and Mental Health Services Administration, for hair testing. So we're soon to have 3 drug testing methods endorsed by the federal government. And when they endorse a drug testing method, which they had not done in over 30 years when those lab-based oral fluid testing guidelines came out in 2019, they're basically saying, if you do this testing method this way, it's accurate. It's legally defensible. We believe the science is solid. And so if you choose one of these drug testing methods as your program or a combination of them, then you're picking a testing method that's been endorsed by the federal government. And if you're following their guidelines, even if they don't necessarily require the use of those guidelines in the states where you do non-government mandated testing, you'll always be able to go back to those regulations and say, this is how we do it. We follow the method endorsed by the federal government. And that adds a level of legal defensibility to your drug testing program that's better than anything else that's out there in terms of protecting the integrity of your program. But let's say, for example, you're testing in a marijuana state. And in that marijuana state, it basically requires the employer to show a connection between impairment and the positive test result for the marijuana. And I'm gonna speed through this so that we can get to these questions, because I see we've got some questions. So you want a testing method with a shorter window of detection, as opposed to hair, which is about a 90-day window of detection, and urine at the drug testing cutoff levels that we use has a detection of somewhere around 4 or 5 days. You can detect THC in urine for weeks, but at the cutoff levels, you're only going to know positives if it's somewhere at or above that cutoff level, which is only going to give you a window of detection of about 3, 4, 5 days. But the drug doesn't become detectable in urine for a period of hours, let's say 8 to 10 hours. The reason for that is that in urine testing, you're detecting in the lab, they're detecting a metabolite of the drug. Whereas with oral fluid testing, it actually has the capability of showing the actual drug, the parent drug as it's called. And so marijuana use becomes detectable in an oral fluid sample almost immediately after the person's used the drug. And the window of detection is a period of hours rather than days, weeks, or months. That's the only federally endorsed drug testing method that shows recent drug use. There is no other method that has that federal endorsement. So if your purpose is to comply with a marijuana law that has this impairment language written into it, lab-based oral fluid testing is the way to go. If you're looking at something with a longer window of detection where you're looking at drug use history, a pattern of drug use, then you want to look at urine or hair testing. That's going to give you a lifestyle look at that individual in a pre-employment test or even in a random test. Why you test determines not just when and who, but also how you're going to test. And a lot of company policies just don't cover these issues. Look at the very top, the first vertical or horizontal bar graph. 45% of employers in a survey didn't even cover the marijuana issue in their policy. This was back in 2017, so hopefully we've made some progress since that survey was conducted. But very, very important that we cover marijuana in the workplace. And let me just go through a few of these real quickly so I can get to this last couple of slides. So we leave some good 10 minutes or so for Q&A. So let's say you're trying to figure out if it's worth doing drug testing. Let's say you have a company of 250 employees, and you're going to multiply that 250 by the percentage of substance abusers in your workforce. The national average is 15 to 17%, but let's say your company is exceptional and only 5% of your workers have a drug problem. So multiply that times $7,000, which is the annual cost per substance abuser per year. Of course, it can be more than that, right? Because the average cost of a workers' comp claim is around $24,000. But if you take all of those numbers and you do the math, essentially it comes out like this. The 250 employees times 5%, because your company is so exceptional, is 13 workers. So you have 13 drug users in your employment. Times $7,000 per year means those 13 individuals are costing you $91,000 a year. Now compared to the cost of your drug testing program. Let's say out of 250 employees, you're doing 300 tests a year. You're doing a lot of hiring, you're doing a lot of random testing, and you're paying $45 a test. I just picked a number. We could say at 35 or 55, it's still going to work out the same way. That drug testing is costing you $13,500. If you subtract the cost of your drug testing program, in this case, from the cost of substance abuse, you'll see that you come out with a return on investment of $77,500 by eliminating hiring those drug users or randomly having them test positive, being able to identify them before they can cause an accident. On this slide, you just see that I've just upped all the numbers. So if you want to be a little bit more dramatic about it, the cost will go up. The cost of drug testing maybe goes up as well. But no matter how you do the math, drug testing still makes sense. It's still a bottom line winner for employers, and employees that don't use drugs like working for companies that have drug testing programs in place. So I know that there's some questions that have been submitted. So let me pause here and turn it back over to Jeff for any questions that may have been asked.